So finally, we need to look at the constraints on competence, in particular the principles of subsidiarity and proportionality. Now, these are found in Article 5, 3 and 4 of the treaty. So I'm just turning to the relevant part, and you will want to do the same. So this is the Treaty on European Union. So Article 5.3 says, under the principle of subsidiarity, in areas which do not fall within its exclusive competence, so we already know which areas those are, the Union shall act only if and insofar as the objectives of the proposed action cannot be sufficiently achieved by the Member States, either at a central level or at a regional and local level, but can rather, by reason of the scale or effects of the proposed action, be better achieved at Union level. The institutions of the Union have to apply the principle of subsidiarity as laid down in a protocol, which is an additional part of the treaty. And national parliaments are required to ensure compliance with the principle of subsidiarity in accordance with the procedure set out in that protocol. Article 5 TEU subparagraph 4 says, under the principle of proportionality, the content and form of Union action shall not exceed what is necessary to achieve the objectives of the treaty, and the institutions of the Union are required to apply the principle of proportionality as laid down in the protocol. The Lisbon Treaty's protocol on the application of the principles of subsidiarity and proportionality and its protocol on the role of national parliaments in the EU give further details. Incidentally, the legal value of a protocol annexed to the treaties is the same legal value as the treaties themselves, and that is confirmed in Article 51 of the Treaty on European Union, which says the protocols and annexes to the treaties shall form an integral part thereof. So these constraints on competence, particularly subsidiarity, have both a substantive dimension and a procedural dimension. So the substantive dimension of subsidiarity is the constraint on union competence is a calculation of comparative efficiency. Which level is best placed to take effective action? Is it the European Union level, or actually would action better be taken at member state level? The procedural dimension imposes obligations on the European Commission. And according to Article 2 of the Subsidiarity Protocol, the Commission is obliged to consult widely before proposing legislation. So this is a legal constraint on the Commission's power of legislative initiative. The Commission is formally obliged to write a detailed statement of why the proposal complies with the subsidiarity and proportionality principles. The Commission has to use qualitative and ideally quantitative measures to show why the action has been taken or has to be taken at union level. This transparency requirement allows for potential review, as well as forming an important accountability brake on the Commission's power of initiative. The Subsidiarity Protocol enhances the role of national parliaments in the EU's lawmaking processes. All legislative proposals have to be sent to national parliaments by the Commission at the same time that the Commission sends them to the EU institutions. There's a formal process by which national parliaments may express their concern to the effect that a proposal does not comply with the subsidiarity principle, and that has procedural consequences. This is known as the yellow card procedure, and you can find specific details of it in a good textbook. The yellow card procedure resulted in the European Commission withdrawing a proposal in 2012 called the Monti II proposal on labour law. But the European Commission did so without conceding any breach of the principle of subsidiarity. The Commission has said in an annual report in 2010 that it takes reasoned objections from national parliaments very seriously, especially from larger member states. As Craig and de Burke point out in their textbook, too much deference to member state competence and an overzealous application of subsidiarity can actually lead to regulatory failure, where action is needed at union level to tackle the issue concerned. External migration into the European Union might be a case in point. The sovereign debt and banking crises are another. Business communities indeed prefer a single regulatory structure rather than a multitude of national structures, because a single structure makes market access easier and businesses have to spend less on compliance. We'll be revisiting this point in the internal market part of the module. When you're answering a problem question, something like the European Commission's Toolkit, the European Commission's own toolkit, could help you think through whether the correct legal basis has been used. This toolkit, there's a hyperlink to it in the slide, gives examples of what kinds of reasoning that you could use in your problem questions. So let me give you an example of what I mean. So here's a copy of the toolkit, and it's got a very useful box that gives advice about how the Commission has to justify that a proposal has to be made at European Union level. So, for example, Commission staff are advised, don't just say the subsidiarity principle is respected because the initiative's objectives cannot or could not be achieved sufficiently by member states. Explain that actions by member states could not solve the problem for the following reasons. For example, the spillover effects, the inefficient scale of the project, and so on. So give a specific reason. So another one, the European Commission's toolkit says, don't just say EU action is necessary to level the playing field. Say only EU action could eliminate the costs of up to ever many euros on average that European Union enterprises incur to apply for additional authorisations in every EU host country that they want to operate in. Don't just say union action is needed to avoid the fragmentation of the internal market. Say union action is needed to eliminate the following obstacles faced by producers to enter into other national markets, and list the obstacles, what kind of obstacles are meant. Or, as is shown, this is estimated to be this much. Don't just say union action is needed because of the strong diversity between policies and practices across member states. Say the negative consequences resulting from these diverse or non-harmonised practices leads to significant market entry obstacles, like higher establishment costs amounting to whatever. And the toolkit gives some really useful examples of ones that the European Commission has done and done them well, and it points you to the specific documents which you can find in Eurlex, and if you need some help with that, then come to one of my virtual office hours and I'll show you how to use Eurlex to find any European Union legal document. And it points you to the specific sections. There's also a really useful list of cases on the last page illustrating what the proportionality principle means in practice, with summaries of each case. So these could also usefully form part of your notes. If you would like to do some revision and consolidation with a strong focus on subsidiarity, then you could consider watching this long video, which is a lecture by Professor Susan Milnes of the University of Sussex. I know Sue Milnes well. She's a very, very respected scholar. So that would take you through this material again with somebody else's perspective. It's quite long, but it might be useful for you. If you would like to do some extension work, then you could watch this video. The hyperlink is in the slides from 2017, a little bit out of date. For instance, it refers to the Juncker Commission, by a a freelancer who used to work for the European institutions. It's 21 minutes long, and it argues that the European Union is de facto a federation by distinguishing headline sovereignty from effective sovereignty. So if you're going to do this, what I suggest you do is you listen to it and you then do the following. You outline the key steps in Stavry's argument, and you add relevant legal references to each point of the argument, because the legal references are not actually made in the 21 minutes. And then think whether you can think of counter-arguments. How would you respond to the position that Stavry is outlining? And support these with some legal references and some examples. And then for further extension work, you might want to think about questions like, is sovereignty really like a pie? So if somebody has some of it, someone else can't also have the same piece. Or is it more like virginity, which can be lost to the mutual benefit of both parties under circumstances, of course, of appropriate consent? This is an argument that's been around for a while, since the 1980s, I think, was originally made, I believe, by Neil McCormack. Think about what you think about the idea of effective sovereignty, which is Stavry's underlying argument. Is that an input, a process, an output, or a democracy analytical frame? How does it fit within that analytical frame that we looked at last week? What do you think about the idea of the European Union as an agent of the member states? Does it make sense to think about the European Union as an agent of the member states? To what extent does that work as an analytical framework to explain the legal dimensions of competence? Which ones does it work to explain, which not? Sometimes, says Stavry, what is good for the Union as a whole is detrimental to the interests of a given country or a group therein. And we saw that with the Czech firearms case. Wherever such circumstances arise, the latter can do little more than ultimately conform to the will of the supranational level. Think about, is this really the case once you take into account the legal constraints on the Union? Does it really depend on the specifics? How might we work from the specifics to more general analytical conclusions that can be supported by the specifics about the balance of power to make law and policy in the EU? And finally, I would invite you to consider questions of positionality. How does a person's position, their lived experience, affect their likely analytical understandings? And you might want to think about this in terms of Stavry, who is a Greek freelancer who works on the EU's politics and policy. Greece is a relatively small, relatively powerless state within the EU. You might want to think about my positionality in terms of being a professor in a country that has been a member state of the EU and has now left the EU. Or you might also want to think about your own positionality and those of your colleagues in your operating team and so on. How does your lived experience affect your analytical understandings? Just to finish up, what do you need to do next? You need to be engaging with the electronic workbook. If you haven't yet finished it, please press ahead and get it done. It has to be done in time for your small group tutorial, which is coming up before too long. And you need to be engaging with your operating team in order to prepare for the workshop, because that's how this module works. So please do be doing those things. Finally, don't forget that we're here. If you would like to talk through any aspects of this work, or your work in the electronic workbook, or anything else about this module, or your learning more generally, in fact, please do pop in and see me virtually. So I have 2 office hours a week. I also have a virtual water cooler hour in my diary now at 10:30 each day. It's a drop-in. You can just tell Google Calendar that you're coming. You'll find details of all of this via Google Calendar, or if you can't make Google Calendar work, email me for appointment. We will be here, won't we, Corrie, to help the students with their work. Thanks very much for listening, and I will see you in the next lecture.